Welcome to the Deep Dive. Today, we're tackling a really important topic for a lot of people here in California: renters' rights during natural disasters.
That's the title, yeah.
But interestingly, while that's the focus, the actual information we've been digging into gives us a much sort of wider picture of your rights as a tenant overall in the state.
Exactly. Things like, moving out, security deposits, what happens with repairs, evictions, the real nuts and bolts.
Right. So our mission really for this deep dive is to pull out the most crucial bits of info on these general rights for California tenants.
And it's worth noting, like you said, the sources didn't have a ton of specifics on during a disaster itself. But they did mention that tenants who are displaced, say by wildfires or something similar, might have some extra leeway, maybe extended time for rent or options to end the lease. So we'll keep that in the back of our minds.
Okay, good point. So let's map this out. We're going to cover, first, the rental agreement itself seems like the starting point for everything. Then how to properly give notice when you plan to leave. Security deposits, obviously. Everyone wants to know about those.
Always a hot topic.
Yeah. Also, the landlord's duty to keep the place, habitable, and what you can actually do if repairs aren't made.
And evictions, too, the rules around just cause.
Right, evictions. And move-out inspections, that seems useful. Plus maybe some proactive steps you can take to try and avoid problems in the first place.
And just so you know, this deep dive is based on our look at resources that focus specifically on representing tenants here in California, not landlords.
Okay, great. So the rental agreement, that first document you sign, it sounds like it really is the bedrock.
It absolutely is. Before you even get close to moving out, you really need to understand what's in that lease or rental agreement.
Read the fine print, basically.
Yeah. Exactly. Is it fixed term, month to month? What notice does it say you need to give? What are the specific rules it lays out about your security deposit? Getting clear on that stuff right at the beginning can save you so many headaches later on. It just, sets the stage.
Right. Sets the rules of the game from day one. Okay, so fast forward, you've decided it's time to move. What's the deal with giving notice? What does the law require?
Well, it mostly hinges on what kind of lease you've got. If it's a fixed term one, like for a whole year, technically you often don't have to give written notice when it ends on the specified date.
Oh, interesting.
Yeah, but it's still a really good idea to let your landlord know your plans maybe 30, 60 days out. Just helps things go smoothly.
Makes sense.
Now, if you're month to month, which is pretty common, California law is crystal clear.
Yeah.
You must give your landlord at least 30 days written notice before you move.
30 days written. Okay.
And for those less common week-to-week arrangements, it's 7 days written notice.
So that written part is key. You can't just mention it in passing.
Nope. A verbal heads up is nice, but it won't cut it legally. You need that formal written notice.
Okay.
And a smart move is to send it certified mail, return receipt requested, or, hand deliver it and get some kind of written proofs they received it. Just creates a paper trail.
Audit covers your bases. All right, let's switch gears to something that causes a lot of stress. Security deposits. Getting that money back. What are the tenants' rights there?
California law is actually pretty strong on this for tenants. Your landlord has a very specific deadline, 21 calendar days after you've officially moved out.
21, that's precise.
It is. Within those 21 days, they have to either give you back the entire deposit or send you an itemized statement.
Itemized, meaning detailing any deductions.
Exactly. A written list explaining exactly what they deducted money for, plus whatever amount is left over from your deposit. They can't just keep it without explanation.
Okay, and what can they legally deduct for? It can't just be anything, right?
No, definitely not. The law spells it out. It's basically limited to things like unpaid rent or utilities you still owe.
Makes sense.
The cost to fix damages that go beyond normal wear and tear, so, a big hole in the wall, yes. Faded paint, probably not.
Right. Wear and tear is expected.
Exactly. And also reasonable cleaning costs, but only if you left the place significantly dirtier than when you moved in, beyond just normal tidying up.
Okay.
And something else to keep in mind, starting July 1st, 2024, there are new limits on how much deposit a landlord can ask for upfront. Generally, it's capped at 1 month's rent for unfurnished places and 2 months' rent for furnished.
That's a big change. Good to know. What if the landlord blows past that 21-day deadline, or you think the deductions are totally unfair?
You have recourse. If they don't follow the rules, you can absolutely pursue getting your deposit back.
Mhm.
And potentially you could even get extra money, what they call statutory damages, basically a penalty against the landlord.
Wow, okay.
A good first step is usually sending a formal demand letter again. Certified mail is best, laying out why you think they're wrong. If that doesn't work, small claims court is often the next step.
Okay, so there are ways to fight back if needed. Let's talk about the condition of the place while you're living there. What's the landlord's basic responsibility?
Landlords in California have a legal duty. It's called the implied warranty of habitability. Basically, they have to keep the property in a condition that's fit for people to live in.
Habitable, meaning?
Meaning essential things need to work. Functioning plumbing, heating, electricity. The place needs to be structurally sound, safe from hazards, weatherproofed. It's a fundamental requirement. They have to make necessary repairs to keep it that way.
Okay. And what if they don't? What if something breaks and the landlord just isn't fixing it? What can a tenant do?
If you've given them proper written notice about a serious problem affecting habitability, and they haven't acted in a reasonable time, often considered about 30 days, but maybe less if it's urgent, you do have some potential remedies.
Like what?
One is the repair and deduct remedy. Under very specific circumstances, you might be able to pay for essential repairs yourself and then subtract that cost from your next rent payment. But there are strict rules. The problem has to be serious, it can't be something you caused, and the cost can't exceed 1 month's rent, usually.
Seems a bit tricky.
It can be. Another more drastic option for really major issues is rent withholding. Basically, you stop paying rent until the repairs are done.
Whoa, that sounds risky.
It absolutely is. There are very specific legal requirements you have to meet, like potentially putting the rent money aside in an escrow account. It's really, really important to understand the law perfectly or get legal advice before even thinking about withholding rent. It can backfire badly if done wrong.
Okay, noted. Legal advice is key there. And documentation, I assume.
Always. Keep copies of all written repair requests, photos, communication, everything.
Makes sense. Okay, let's talk eviction. What grounds does a landlord actually need to evict someone in California? Can they just decide they don't like you anymore?
Generally, no. Thanks to the Tenant Protection Act, AB 1482, most landlords need what's called just cause to evict tenants who have lived there for a certain amount of time.
Just cause, meaning a legitimate reason.
Exactly, a legally recognized reason. And these fall into two main buckets: at fault and no fault. The whole idea is to give tenants more stability and prevent unfair or arbitrary evictions.
Okay, break down those two types for us. At fault versus no fault.
Sure. At fault, just cause means the eviction is supposedly because of something the tenant did wrong, like not paying rent is the classic one, or seriously violating the lease, maybe having a pet when it's explicitly forbidden, creating a major nuisance, damaging the property, or using it for illegal purposes.
Okay, things the tenant is responsible for. What about no fault?
No-fault reasons aren't about the tenant's behavior at all. They're about the landlord's plans for the property. This could be the landlord wanting to move in themselves or have a close family member move in.
Ah, okay.
Or maybe they're selling the property to someone who intends to live there. Or they're planning really substantial renovations that require the unit to be empty. Or, in some cases, they're taking the property off the rental market entirely.
Got it. And the process, like the notice they have to give, is it different for those two types?
Yes, it is. For no-fault evictions, landlords usually have to give you more notice, often 60 days written notice. And importantly, in many cases of no-fault eviction, they also have to pay you relocation assistance, money to help you move.
Oh, relocation money. That's significant.
It can be. For at-fault evictions, the notice periods can be shorter, like a 3-day notice to pay rent or quit if you haven't paid rent.
3 days isn't much time.
It's not. And this is critical. If you get any eviction notice, whether you think it's valid or not, you generally have only 5 calendar days to formally respond in writing to the landlord and file a response with the court if you want to fight it.
Wow, only 5 days. That's incredibly fast.
It really is. That's why if you get an eviction notice, getting legal help immediately is so important to figure out your rights and options. Don't just ignore it.
Absolutely. Okay, shifting to the end of the tenancy, the actual move out, is there anything a tenant can do before they hand back the keys to maybe head off arguments about the security deposit?
Yes, definitely. California law gives tenants a specific right you should know about. The right to request a preliminary inspection, sometimes called a pre-move-out inspection.
A pre-inspection, how does that work?
You can ask for it after you've given your notice to move out, but it has to happen within the last 2 weeks before your tenancy ends.
Okay.
The landlord, or their agent, walks through the unit with you, and the whole point is to identify any potential problems like damage beyond normal wear and tear or areas needing more cleaning that they might deduct for later.
Ah, so you get a heads up.
Exactly. It gives you a chance to actually fix those things yourself before you leave, so hopefully you avoid those deductions from your deposit. The landlord is supposed to tell you in writing that you have this right.
That sounds incredibly useful, like a preventative measure.
It really is. If you request it, you agree on a time, the landlord gives 48 hours written notice of the inspection time, and afterwards they should give you an itemized list of potential issues they spotted.
Smart. Any other proactive things tenants should do when moving out?
Yeah, a few good practices. We already talked about reviewing your lease first. Make sure you give that proper written notice and keep a copy.
Right.
When you actually move out, try to do a final walkthrough with the landlord if possible, and document everything. Take pictures, take video, date it if possible, make notes on the condition.
Photos are always good evidence.
Absolutely. Keep all your communication records handy. And, for extra peace of mind, some people even hire an independent inspection service to get a totally neutral report on the condition when they leave.
That's thorough. Okay, this is all great advice, but what if, despite doing everything right, you still end up in a dispute with your landlord? Where can tenants turn for help?
There are several resources available in California, thankfully. Talking to a tenant rights lawyer who knows California housing law is often the best first step for specific legal advice.
Okay, lawyers. What else?
There are many nonprofit groups and legal aid clinics that offer free or low-cost help specifically for tenants. Think organizations like the Public Law Center's Tenant Rights Project or Inner City Law Center. They do fantastic work.
Good to know there's help out there.
Also, statewide groups like Tenants Together are great for information and advocacy. Depending on where you live, your city or county might have its own rent control board or tenant services office. And like we mentioned for deposits, small claims court is definitely an option for certain types of disputes.
And if someone needs assistance specifically as a tenant, where should they look?
For specific tenant representation and further information, you can visit martinezlawcenter.com.
Okay, great. So this has been really comprehensive. Let's just quickly recap the big takeaways.
Sounds good.
Your rental agreement is key. Know what it says. Always give proper written notice to vacate 30 days for month to month, 7 for week to week is the standard.
And landlords have that strict 21-day deadline for returning your security deposit or providing an itemized list of deductions. Plus, there are limits now on how much deposit they can ask for initially.
Right. And they have a legal duty to keep the place habitable. If they don't make necessary repairs after written notice, you might have options like repair and deduct, but be careful, especially with rent withholding.
Exactly. And for evictions, just cause is usually required. Know the difference between at-fault and no-fault reasons, and remember that very short deadline to respond if you get a notice.
Don't forget that right to request a pre-move-out inspection. Use it. And documentation, photos, emails, letters is your friend.
Absolutely. And just circling back to where we started while we focused on these general rights, remember, the sources did suggest that if you were displaced by a natural disaster like a wildfire, you might have some additional protections regarding rent or your lease. That's something specific to look into if, heaven forbid, that situation arises.
Definitely. So thinking about all this, for you listening, considering how complex tenant rights can be in California and how important it is to know where you stand, especially when life throws curveballs, what steps will you take now to make sure you're truly informed about your lease and your rights?
It's worth taking that time. And remember, for more detailed information and assistance focused on tenant rights, you can check out martinezlawcenter.com.
Thank you so much for joining us on this deep dive.
Call now 714-442-9741. Thank you.